Now, herein lies a huge problem, which I have recently faced, well, a year and a half back. Everybody knows that first appeal no scope is wide. Under Civil Procedure Code, a first appeal, which is what we understand an appeal under section 96 of the Code of Civil Procedure, very wide scope. So, we were for the respondents. It was an entitled first appeal. And we told the judge that, sir, you cannot go into this question. He said, after all, it's a first appeal. It was not a first appeal in that sense. An arbitral award was passed by arbitrators. It was challenged under 34 by an application before the district court. That order, when it comes to the High Court, by an accident of nomenclature, is called a first appeal. But in scope, it is much more restricted than a first appeal under 96. But the courts to which division bench first appeals are assigned will be taking it up one after the other. And sometimes the judges are not mindful of this, that one first appeal is quite different from another first appeal. Just to go back, a 10F appeal under the Companies Act section 10F, is on a question of law only. So though it is called a first appeal, it is on a question of law. Therefore, please understand that nomenclature is important. If you goof up, and you will goof up, all of us have, you will goof up. If you goof up, don't display a casualness and ask the court, okay, then convert it. Laugho padse. Na thayo. Please accept that you've goofed up and request if possible. Some courts do it, some courts don't. Depends તમારું નસીબ એ દિવસે કેવું છે. Okay. Then, again touched upon by Asim, in the matter of what? So, Mr. Pandya would say that you just write this much and that's enough, which it is. If it's a writ or a petition under Article 226, we won't call it a writ petition. But here also is an important tip. Whether we like it or not, different judges have different views. Accept it, get used to the fact. One petition, if heard by Judge A, you will succeed. Heard by Judge B, you will fail. Forum shopping is a dirty phrase. Forum shopping means you choose which judge before whom you go. We never do forum shopping. It is illegal. Having said that, you will face adversity or you will get benefit depending on chance. And that chance is sometimes governed by which court before whom your case lands up. So if you write against the arbitrary decision of Special Secretary dated so-and-so, 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 chances are it may be considered a 226 petition and go before a learned single judge. But if you write decision dated so-and-so, passed in contract number so-and-so, pursuant to tender number so-and-so, it will go before a division bench. And on this decision, will the success or failure of that case and your client's fortunes depend. So be careful. I faced this just recently. So one case was filed in the family court. It purported to be an application for guardianship of a minor The hearing is concluded. I am commenting not upon the merits of it, but અત્યારે pending છે case. So it will be of some immediate freshness. So father filed for custody of minor to exclude the mother. Order was passed in favor of the father. I was for the mother. So we challenged it. We challenged it in a special CA against order of civil judge or lower court. It came before Judge A. The Judge A heard the matter at some considerable length. 3 or 4 days he heard the matter. Then one day when I was sitting before another learned single judge, I saw that 4-5 guardians and wards ni special CA અહીંયા આવી. So I asked my instructing advocate and my clerk, I said, sitting lao. And we realized that there was a large set of matters arising from lower courts and lower tribunals, but a smaller subset of petitions arising from Guardians and Wards Act. So we were before a court which had no jurisdiction. Neither the court knew it, nor I knew it, nor the other side knew it. Now it was deeply embarrassing for me to point this fact out to the learned single judge, because the learned single judge was against me. So I consulted some senior friends and I said, look, as per the Supreme Court judgment, if a judge who is not assigned the business hears it, the order is a nullity. So whatever happens, my counterparts in the Supreme Court will not be so shy to point out this mistake. Neither will my client. So I said, Judge ne to kehvu padse ke sahab tamarthi nahi samblaya matter, even if you have heard it. So we arrived at a compromise solution in our heads along with my senior friends, that we tell the judge that you have no jurisdiction, the matter will be referred to the Chief Justice, but we will undertake before the Honorable Chief Justice on the administrative side that we have no objection to this matter being assigned to that very learned judge. So the other side thought that we were playing fast and loose and it was a cheap shot. Anyway, long story short, judge said to be placed before the Honorable Chief Justice for special assignment. So we communicated that we have no objection to the matter being sent back. Predictably, the Honorable Acting Chief Justice, as he was, sent the matter back to the same judge. So I said, chalo, હવે તો argue કરવી જ પડશે. તો અમે ઊભા થયા. Then the judge said, not before me. So then it went to a third judge. It went to a third judge because it went back to the Acting Chief Justice, and the Acting Chief Justice said, then he should have sent it, God bless him, to the court which took up Guardians and Wards matters. But he didn't do that. He said, ત્યાં તો નહીં મોકલું હવે. He sent it somewhere else. That is his prerogative. Okay, so what kind of act you write in the matter of, it is a matter of immense practical importance. So be careful about that. Then we come to the cause title. Okay, so we are still on the first page. And most of the mistakes that lawyers make are not of substantive law. In substantive law, a 5-year course student in the matter of substantive law and research is probably better than many of you here. But what separates the men from the boys and the women from the girls is procedure. So, parties to the petition. That should also be obvious. कौन अरजदार थશે? Be careful about maintaining the integrity. Much of the work we have, in fact very little original work in the High Court, even writs which are called original are derivative. There is always a bandhailu cause title of some lower tribunal or court or authority. Retain that. Retain that cause title, otherwise office will not circulate your matter. એમાંથી કોઈ મરી ગયું હોય તો હવે મરી ગયેલાનું નામ તો રાખજો જ, પછી એના વારસો 4/1, 4/2 એ રીતે મૂકજો. Many matters get stuck at the registry stage because જે lower courtના proceedingsમાં cause title હોય એ તમે હાઈ કોર્ટમાં મેન્ટેન ના કર્યું હોય તો આ મેટર અટકી જશે. There will be an office objection. So parties' integrity must be maintained. But there are some matters which are completely original. સીધી એડમિનિસ્ટ્રેટિવ ઓથોરિટી એક્ઝિક્યુટિવનો ઓર્ડર પરથી આપણે અહીંયા આવ્યા હોઈએ કે રજા ચિઠ્ઠી આપી છે નથી આપી ઓર ધોઝ થિંગ્સ. ત્યારે બી કેરફુલ કે હુ ઇઝ ધ રોંગ ડુઅર. અને ઘણીવાર આપણે સ્ટેટને તો જોડી જ દો, ડિસ્ટ્રિક્ટ કલેક્ટરને જોડી જ દો. ડોન્ટ બી સો કેઝ્યુઅલ. If the order is passed by an instrument of local self-government, that is to say a panchayat or a municipality or a corporation, then join only them. Why join the state government? Why join Secretary Urban Welfare Department merely because the matter arises from some urban agglomeration? Do not add to the number of enemies you have. Keep them to a bare minimum. કે તલાટીને બી હાથ જોડ્યા અને પછી ટીડીઓને બી જોડ્યા અને પછી કલેક્ટરને બી જોડ્યા. જે મતલબનો માણસ હોય એને જોડો. The person who is interested in sustaining the order, that person has to be joined. The person at whose behest that order is passed may or may not be joined. There is some debate on that. But if it is an administrative authority, you better join that administrative authority. Mr. Pandya will disagree with the Supreme Court that the tribunal should be joined or not joined. That is એમાં કોઈ પ્રશ્ન થાય તો અસીમભાઈને પૂછજો, મને ના પૂછતા. Then we have પક્ષકારોની ઓળખ આપવી is very important. In your first paragraph, incidentally, this most respectfully Shwet that is an archaic, outdated and useless formulation. We should drop it. Courts from whom we derive jurisdiction historically have all dropped it long back. I have seen English and American summonses. They are used in vernacular. Injunctions are issued in vernacular language. Dad shall have no custody. That is what orders read. આપણને લાંબુ લાંબુ લખવાનો નો શોખ છે. There is no merit in that. Respectfully submitted that colon any નીચે લીટી અને શરૂ પડી જવાનું. Okay, so if you stop writing to the Honorable the Chief Justice and his companion justices of the High Court of Judicature at Ahmedabad, the only person who will be happy will be your typist or your steno, because એમાંને એમાં એક પાનું જતું રહેશે. Okay. Then I will dwell upon this who is to be made party for the respondent. If you are seeking writs, this is the position of law as it stands now. The 5-judge bench judgment, among the many things that it said, was that 226 can only be there if that concerned tribunal which has passed the order has been made a party. Why is this great love and affection for 226? Because 226 હોય તો LPA થઈ શકે, 226 ના હોય તો સીધા સુપ્રીમ કોર્ટ, અને સુપ્રીમ કોર્ટના પૈસા બહુ ઘણા પાસે નથી હોતા. So there's this great fight amongst the lawyers and amongst the judges come to that. 5 learned judges sat for several days and came to the learned conclusion, amongst the many learned conclusions that they came to, that if there is no joining of the concerned tribunal at the stage of the writ petition, then it is not a petition under 226, it is a petition under 227, and since it is 227 revisional powers, no letters patent appeal. Incidentally, the Gujarat High Court has been quite keen whenever it has got the opportunity to disclaim jurisdiction, a trait markedly absent in other courts like Delhi and Bombay, which always take jurisdiction. We are very keen to give away. That is a curious feature of the judicial mindset here. No judge is present here, so I can say this freely. Jurisdiction જતું શું કરવા કરો છો? Accept jurisdiction. કે ના, how can I do this? એ પ્રશ્ન આપણા જજોના માઇન્ડમાં foremost હોય છે. So we challenged some of those orders in, I think, 2015, 9 SCC page 1 is that reported decision. I had also addressed the Supreme Court. So the judgment of Justice Deepak Mishra and Justice Nick Goel, Adarsh Goel, very learned one. This is the second one. But the hearing which took place was quite casual, and it was as casual as this talk, with Hindi coming in. And so they said, what is your matter? So I said, my matter is that it arises from a adjudication by the authorities under Provident Fund, and I filed a petition before the learned single judge. Single judge dismissed it. Then we filed an LPA. During the LPA, वो ख्याल आ गया कि ट्राइब्यूनल को ज्वाइन अगर नहीं किया है, दिस इज हाउ इट्स गोइंग ऑन इन द सुप्रीम कोर्ट, ट्राइब्यूनल को ज्वाइन नहीं किया है तो खारिज कर देंगे. सो बिकॉज दैट टाइम देयर वाज अ मूव हियर, some judges were saying, okay, join the tribunal, then we'll hear your LPA. So he said, okay, let's join the tribunal. No amount of theory comes in here. You take the practical option and we join the tribunal. But farti matter jare ek particular division bench paase aavi, they said no, now we are bound by the 5-judge bench judgment. And the 5-judge bench in their infinite wisdom said that even if the tribunal is joined at a later stage, LP is not maintainable. So the Justice Deepak Mishra says, ऐसा कहा? I said, हाँ sir, ऐसा कहा. अच्छा, what is your matter? The guy says, same. He said, no, it can't be that only because tribunal is joined or not joined, LP is not maintainable. I said, look at the order. So the imputed order says, in view of Fala judgment, since the tribunal was not joined before the learned single judge, this LP is not maintained. He said, that's all? I said, yeah, that's all. So hearing, then Hari Vishnu Kamat and everything was, then the Supreme Court lawyers are always smarter than us. They've always prepared better, so they have to show कि हमने कुछ पढ़ा है. तो 1-1.5 घंटे बहस चली, but मौके का तो यही हुआ. And at the end of 1.5 hours, Justice Mishra says, okay, हम